Voting by committee. Regulation 25 of IBBI, the said regulation provides the following regard voting by committee. So, the action listed in 28.1 shall be considered in meeting of committee. Any action other than those listed in 28.1 requiring approval of committee may be considered in the meeting of C committee. The resolution professional shall take a vote of members of the committee present in the meeting on any item listed for voting after discussion on the same. The resolution professional shall circulate the minutes of the meeting by electronic means to all the members of the committee and the AR, if any, within 48 hours of the conclusion of the meeting. Sorry, I missed one para. At the conclusion of a vote at the meeting, the RP shall announce the decision taken on items along with the names of the members of the committee who voted for or against the decision or abstain from voting. So, for, against and abstain, 3 of them will be recorded. The RP shall circulate the minutes and seek a vote of the members who did not vote at the meeting on the members listed for voting by electronic voting system in accordance with Regulation 26, where the voting shall be kept open from the circulation of our minutes for such time as decided by the committee, which shall not be less than 24 hours and not exceeding 7 days. So, minimum 24 hours, max 7 days. On a request for extension made by the creditor, the window shall be extended in increment of 24 hours period, provided further that RP shall not extend the voting window where the matters listed for voting have already received the requisite majority. So, if requisite majority received, again he will not open. If not, then he will open. And one extension has been given after the receipt of requisite majority vote. Even after majority has been achieved, one time extension will be. AR shall circulate the minutes of a meeting received by RP to creditors in class and announce the voting window at least 24 hours before the window open for voting instruction and keep the window open for at least 12 hours. Regulation 25 provides for voting by AR. It implied that authorized representative shall cast his vote in respect of each financial creditor or on behalf of all financial creditor he represent in accordance with the provisions, as the case may be. Process of inviting resolution plan by the committee. The process of inviting resolution plan by the committee of creditor is most crucial step in the revival and rehabilitation of the stressed corporate debtor. In return, will decide the future of the corporate debtor. The process includes following measures to be taken on the part of RP: issuance of expression of interest, request for resolution plan, strategy for marking of asset of the corporate debtor, receipt of resolution plan from the prospective resolution applicant. Each of the stages discussed. First, issuance of expression of interest, form and manner of issue of EOI. So, Regulation 36A provides for the EOI of interest as follow. Within 60 days of the insolvency commencement date, the RP shall publicize brief details of the invitation for EOI in Form G from interested and qualified potential resolution applicant to submit the resolution plan. Form G shall be published in English and regional language newspaper at the location of registered office and principal office, if any, corporate debtor, and any other location wherein opinion of RP the corporate debtor conducts material business operation. Next, newspaper done, and next, website of corporate debtor and website, if any, designated by the board for the purpose and in any other manner as decided by the committee. Form G shall state from where the detailed invitation for EOI can be downloaded. It should also provide for last date for submission of EOI, which shall not be less than 15 days from the date of issue of detailed invitation. 15 days from the date of issue of detailed invitation. The detailed invitation refer shall include the criteria for prospective resolution applicant as approved by committee in eligibility norms under 29A of the code. Information about the corporate debtor as may be required by the prospective resolution applicant for EOI and shall not require payment of any fee or non-refundable deposit for submission of EOI. Any modification for EOI shall not be made more than once. The prospective resolution applicant meeting the requirements of the invitation for EOI may submit EOI within the time specified in the invitation. The EOI received beyond the timeline specified in the invitation shall be rejected by the RP. So, RP cannot reject the resolution plan, but RP can reject the EOI. Content of expression of interest. Regulation 36A of the IBBI regulations: an expression of interest shall be unconditional and shall be accompanied by first an undertaken by the prospective resolution applicant it meets the criteria. So think like expression of interest. Who will give the resolution applicant who want to express their interest that I am ready to take over, I am ready to buy the company in the IBC. So they are giving. So think of the resolution applicant point of view. What he is giving? First, undertaking that prospective resolution applicant that it meets the criteria specified. And next, relevant record is in the evidence of meeting the criteria. So first point related only B, and even third also related, like he gives an undertaking by the prospective resolution applicant that it does not suffer from any ineligibility under 29A. So 29A should not be there. And fourth is related to C, relevant information and record. So relevant information and records to enable an assessment of ineligibility under section 29A. And next E also undertaking by the prospective resolution applicant that he shall intimate the resolution professional forthwith if he becomes ineligible. Okay, forthwith means immediately, soon. An undertaking by the prospective resolution applicant that it shall that every information and record provided in EOI is true and correct, and discovery of any false or record at any time will render the applicant ineligible to submit the plan and forfeit any refundable deposit and attract penal action under the court. An undertaking by the prospective resolution applicant to effect that it shall maintain confidentiality of the info and shall not use such info to cause an undue gain or undue loss to itself or any other person. Issuance of provisional list of eligible prospective resolution by the resolution applicant. Printing error, actually it is by resolution applicant, resolution professional. So RP shall issue a provisional list of eligible resolution applicant within 10 days from the last date for submission of EOI. So from EOI, last date of EOI, when the last date was there, from then in 10 days he will make the provisional list and issue the provisional list to the resolution applicant. The members of the this will be issued to members of the COC and to all the prospective resolution applicant who submitted the EOI. And any objection to inclusion and exclusion, both inclusion exclusion, why my name is included, why other name is not excluded, in any other way, inclusion and exclusion for both of a prospective resolution applicant in a provisional list may be made with supporting docs within 5 days from the date of issue of provisional list. So from last date of EOI, in 10 days he will make a provisional list, and from provisional list making date, from then in 5 days he can raise the objections. On considering the objection received, if any, RP shall issue a final list of a prospective resolution applicant within 10 days of the last date for receiving the objection to the COC. So first, RP issue prospective applicants within 10 days from last of EOI, and after he issuing the prospective provisional list, in 5 days can raise the objection, and last date of raising objection from then in 10 days he will make the final and submit to COC. Next, request for resolution plan. Regulation 36B. Regulation 36B of IBBI regulations provide the RP shall within 5 days from the date of issue of final list issue the info memorandum, evaluation matrix and a request for the resolution plan to every applicant in the final list, provided that where such docs are available, the same may also be provided to every prospective resolution applicant in the provisional list. The request for resolution plan shall detail each step in the process and the manner and the purpose of interaction between the resolution professional. The request for resolution plan shall detail each step in the process and the manner and the purpose of interaction between the resolution professional and the prospective resolution applicant along with the corresponding timeline. The request for resolution plan shall allow prospective resolution applicant a minimum of 30 days to submit the resolution plan. So 30 days time will be given. First, resolution plan within 5 days of finalist, he will give all the 3 documents, and 30 days time will be given to applicant to submit the plan. The request for resolution plan shall require the resolution applicant to provide a performance security. So resolution applicant should provide a performance security within the time specified therein, and such performance security shall stand forfeited if resolution applicant of such plan after its approval AA by the AA fails to implement or contributes to the failure of the implementation of the plan in accordance with the terms. Performance security meaning any modification in the request for resolution plan or evaluation metrics issued shall be deemed to be a fresh issue, shall be subject to the above mentioned timeline, and such modification shall not be made more than once. So modification only once. The resolution professional, the RP may with the approval of committee extend the timeline for the submission of resolution plan. So if COC allows, he can extend the timeline. The RP does not receive any resolution plan in response to the request under this regulation, he may with the approval of COC issue request for resolution plan for sale of one or more assets of the corporate debtor. So if he cannot receive the plan, individual sale of asset. RP with the approval of committee reissue request or resolution plan. The RP may with the approval of committee reissue request for resolution plan if the resolution plan received in response to an earlier request are not satisfactory, subject to the condition that request is made to all prospective resolution applicant in the final list. So again reissue request can be made. And meaning of evaluation metric. Next, strategy for marketing of assets of the corporate debtor. Strategy for marketing of assets of the corporate debtor. So if resolution plan not got, then you have to do the strategy for marketing the assets so that more value can be gained. The RP shall prepare a strategy for marketing of assets of corporate debtor in consultation with the COC, where the total assets as per the last available financial statements exceeds 100 crore, and may prepare a such strategy in other cases. Decision of implementing such strategy along with cost shall be subject to the approval of committee. The member of committee may also take measures for marketing. So even members of the COC shall also take measures to marketing of the assets of corporate debtor. From the above amendment was introduced with an objective to maximize the value of assets of corporate debtor undergoing CIRP. Value of assets of the corporate debtor can only be maximized when there are multiple resolution plans submitted by the prospective resolution applicant and a price discovery takes place through competitive bidding among such prospective resolution applicant. To increase the interest and promote participation of large number of prospective resolution applicant, the availability of the asset in the market needs to be made known to a large audience and specifically targeted outreach to prospective resolution applicant. Next D, receipt of a resolution plan from the prospective resolution applicant. Regulation 37 of IBBI regulations provides that resolution plan shall provide for the measures for the resolution of insolvency of corporate debtor along with maximization of value of assets, including but not limited to following: transfer all or part of the assets, sale all or part of the assets, restructuring of a corporate debtor by way of merger, amalgamation and demerger, substantial acquisition of a shares of a corporate debtor or merger or consolidation of the corporate debtor, cancellation or delisting of any shares, curing or waiving of any breach of the terms, reduction in the amount payable to the creditors, extension of a maturity date or change in interest rate or other terms of a debt due from the corporate debtor, amendment of constitutional docs, issue of securities of corporate debtor for cash, property, securities or in exchange of the claims or interest, change in the portfolio of the goods, services produced or rendered by the corporate debtor, change in the technology used by the corporate debtor, obtaining necessary approvals from the CGST and other authorities, sale of one or more assets of the corporate debtor to one or more successful resolution applicants, submitting resolution plan for such asset and manner of dealing with remaining assets. Regulation 38 provides that mandatory content of resolution plan shall be followed. The amount payable under a resolution plan to OC and FC of the corporate debtor, a statement as to how it has dealt with interest of all the stakeholders including FC and OC, A statement giving details of the resolution applicant or any related parties has failed to implement or contributed to failure of implementation of any other resolution plan approved by the AA at any time in the past, the term of the plan and its implementation schedule, the management and control of the business of corporate data during its term, the adequate means for supervising its implementation, manner in which proceedings with respect to avoidance transaction of the corporate debtor will be pursued after the approval of resolution plan, and the manner in which the proceeds, if any, from such proceedings shall be distributed. A resolution plan shall demonstrate that it addresses the resolution plan shall demonstrate that it addresses the cause of default, is feasible and viable, and resolution applicant has capacity to implement the same. The RP resolution plan should have provision for its effective implementation, approvals required, and timeline for the same. And there is a case law. This is also COC Supreme, and section 29A. This will be known. 29A code expressly prohibit certain group of people from taking part in resolution process. 29A of the code, following persons shall not be eligible to submit a resolution plan. First, undischarged insolvent means he himself is insolvent, he cannot, and willful defaulter according to the guidelines of RBI issued in the Banking Regulation Act, and at the time of submission of resolution plan has an account or an account of corporate debtor under the management or control of such person, or whom such person is a promoter, classified as a non-performing asset in the accordance with the guidelines of RBI. So NPA is there, and at least a period of 1 year has elapsed from the date of such classification till the date of commencement of CIRP of the corporate debtor. So if any non-performing asset is there and 1 year has been lapsed, so he cannot apply for resolution plan. But however, there is an exception that such person shall be eligible to submit a resolution plan if such person makes payment of all the overdue amount with interest thereon. As soon, now only if he want to submit the plan, if he clear the amount and submit, it's okay. And charges relating to the non-performing asset before submission of the resolution plan, it's a valid, and also provides this clause shall not apply to a resolution applicant where such applicant is a financial entity and is not a related party of the corporate debtor. So three things are there in this. First, if a person who wish to submit has an NPA and 1 year has been lapsed, he cannot submit the resolution plan. And second one, if he clears the overdue with interest and all, he can submit the plan. And third, this provision, that is NPA and 1 year lapsed, this provision at all will not apply if applicant is a financial entity and is not related party. Then this provision at all it will not apply. Even if he has a NPA and 1 year lapsed, he can submit the resolution plan. And next, has been convicted for any offence punishable with the imprisonment for 2 years or more under any act under the 12th schedule for or for 7 years or more. So according to 12th schedule, 12th means 2, at last 2 is there, no? So 2 years. And next, 7 years or more under any law, any law for the time being in force. So any law means 7, and 12th schedule means 2 years. This clause shall not apply to a person after the expiry of period of 2 years from the date for his release from the imprisonment. Means 12th schedule is there, na? Expiry of period of 2 years. After 2 years has been expired. So after then he can submit a resolution plan. Whereas for 7 years they not gave this provision. It means for 7 years he cannot apply. Only 2 years. If 2 years has been expired, he can submit a resolution plan, and such a person is disqualified to act as a director. To act director, he is disqualified. So here also will disqualify. Such a person is prohibited by the SEBI from trading in securities or accessing the securities market. Has been a promoter or in the management or control of a corporate debtor in which a preferential transaction, means that 4 transactions, preferential transaction, undervalued, extortionate and fraudulent transaction has taken place, in respect of which an order has been made by the AA under the code. Has executed a guarantee in favor of creditor in respect of corporate debtor against which an application for insolvency resolution made by such creditor has been admitted under the code and such guarantee has been invoked by the creditor and remains unpaid in full or part. Next, such person is subject to any disability corresponding to above mentioned clauses under any law in a jurisdiction outside the India also. If he is not eligible, here also not eligible. Has a connected person, not eligible corresponding to above mentioned clauses. So connected person meaning has been given. And case law, so here the judicial interpretation of section 29A has been taken place of H. Before the Supreme Court, I think loans or credit facilities were obtained by the corporate debtor from a consortium banks. On the failure of corporate debtor to act in tune with the terms of repayment, some of the lender banks were forced to invoke a personal guarantees extended by the promoter of corporate debtor for the credit facilities availed by it. At last, lenders including RBL Bank issued a notice under 13(2) of the SURFACE Act after duly invoking a personal guarantee of the promoter. Later, RBI Bank initiated the CRP under 7 against CD, which was admitted by the AA. 2 resolution plans were received by the RP, of which one was authored by the personal guarantor promoter prior to the introduction of Section 29 Code. Adjudicating authority held that personal guarantor was eligible to submit a resolution plan, notwithstanding the fact that he did not extend his personal guarantee on behalf of the corporate debtor, which were duly invoked by the sum of the creditors. It ruled that as much as a personal guarantee having not been invoked and personal guarantee merely having extended his personal guarantee, as there is no disqualification, only those guarantors who had antecedents which might adversely impact the credibility of the process are allowed to be excluded. A debt payable by the personal guarantors was not crystallized. He could not be construed as a defaulter for breach of guarantee. While the appeal was pending before NCLAT against this order of AA, Section 29 went through a amendment which came into effect whereby it was declared that a person shall not be eligible to submit a plan if he executed an enforceable guarantee in favor of a creditor in respect of corporate debtor against which an application for insolvency resolution made by such creditor has been admitted. So the resolution plan of a promoter was approved by COC. Voting and pending appeal before the NCLAT was withdrawn. The AA approved the resolution plan by its order, inter alia holding that issue the eligibility under 29A decided already, coupled with the resolution plan crossing the requisite threshold of approval by the COC. Having considered the techno-economic viability and feasibility of the plan, the application filed for approval of the resolution plan submitted by the promoter was liable to be allowed. A direction was accordingly given, holding that the approved resolution plan shall come into force with immediate effect. NCLAT confirmed the order of AA on appeal. SC observed that once a person executes guarantee in favor of a creditor for credit facility availed by a CD and the matter has been admitted and the guarantee has been invoked, the bar eligibility under would certainly come into play. What is required to earn disqualification? The said provision is a mere existence of a personal guarantee that stands invoked by a single creditor, notwithstanding the application being filed by any other creditor seeking initiation. If the submission of a plan is maintainable at the time when the petition was filed, thereafter, by the operation of the law, a person become ineligible, which continues either till the time of approval by the COC or adjudication by the AA, then the subsequent amendment provision would govern the question of eligibility. Supreme Court held that resolution plan submitted by promoter of CD was not maintainable due to his ineligibility. However, Supreme Court disposed of the matter without disturbing the approved plan on merits, considering socio-economic factors, the employment of several workers. Actually, guarantee in this case it should not be maintainable, but for socio-economic grounds, so Supreme Court allowed this resolution plan. Approval of resolution plan by the committee. The code has provided the committee with exclusive access to negotiation and also final hand in dealing with the business decision. Thereby, COC is also endowed and responsibility of evaluating resolution plan, thereafter voting and approving the best resolution plan. Regulation 39 of IBBA states the provision of approval of resolution plan by the committee. A prospective resolution applicant in the final list may submit resolution plan or plans prepared in accordance with the code and these regulations to the RP electronically within time given in the request for the resolution plan along with affidavit and undertaking. Affidavit that I am qualified in 29A and undertaking by the applicant that every info and record provided is true and correct, and false he will be liable. Penal action can be taken. Resolution professional may be, if envisaged in the request for resolution plan, allow modification but not more than once. The committee shall not consider any resolution plan if the resolution plan received after the time resolution plan is received from a person who does not appear in the final list. If resolution plan does not comply with the provisions of section 30 clause 2, the RP shall submit all the plans that comply with the provisions of the code of committee. The committee shall evaluate the resolution plan as per the evaluation matrix, record its deliberation on the feasibility and viability of each resolution plan, and vote on all such resolution plans simultaneously. Where only one resolution plan is put to vote, it shall be considered approved. Only one means it is considered to approved if requisite votes, that is 66% has got. Where two or more resolution plan are put to vote simultaneously, the plan which receives highest vote but not less than the requisite, means highest means it should receive 68, 69 like that. Where two or more resolution plan received equal votes but not less than requisite votes, the committee shall approve any one of them as per the tiebreaker formula announced before voting. Where none of the resolution plan receives requisite votes, the committee shall again vote on the resolution plan that received the highest vote subject to the timeline under the code. Where none of the resolution plan receives requisite, means two plans were there, on two got 60-60, so both will be again put to vote. The resolution plan shall send a copy of order of AA approving or rejecting plan to participants and resolution applicant. Effect of approval of plan by the AA. The RP shall within 15 days of the order of AA approving the resolution plan inform and intimate each claimant for payment of debt under resolution plan, and no proceeding shall be initiated against the IRP or RP for any actions of the corporate debtor prior to insolvency commencement date. Within the insolvency commencement date, any action done for that IP or RP liable if he was dealt with it in wrong way. Preceding matters of corporate debtor, for that he cannot be held liable. A person in charge of the management or control of the business and operations of the corporate debtor after a resolution plan is approved by the AA may make an application to the AA for an order seeking the assistance of the local district administration in implementing the terms of the resolution plan. A creditor who is aggrieved by the non-implementation of the approved resolution plan may apply to the AA for directions. Section 31 subsection 1 of code provides that AA has approved the resolution plan. AA has approved the resolution plan, then such plan shall be binding on the corporate debtor, employee, member, creditor, CG, SG, local authority, guarantees. On all it will bind. 31(2) of the code provides that where AA is satisfied that resolution plan does not conform to the requisite requirements, it may order reject the resolution plan, but only legality it can check. Section 31(3) of the code provides that after the approval of resolution plan, the moratorium order passed under 14 shall cease to have effect. 32A also provides that liability of a corporate debtor for an offence committed prior to commencement shall not be shall cease and corporate debtor shall not be prosecuted for such an offence from the date of resolution plan has been approved by the AA if the resolution plan result in the change in the management or control of the corporate debtor. Means corporate debtor is not liable even for the offence committed prior to the commencement of the CRP. And case laws. First one, if COC approved the resolution plan, cannot be viewed as a solely contract. Due to nature of IBC, COC approved a plan do not fall under the common law remedies or withdrawal or change or force majeure. It would be contrary to IBC insolvency system. So it cannot be dealt by the covered by in the Contract Act as a contract. Next, PNC, COC is the supreme, and evaluation matrix regarding evaluation matrix and the means COC is the supreme, that's all. And in next case also COC is the supreme, so that process can be completed within the timelines. Special provision relating to timeline. Section Regulation 40C of regulations was inserted in 2020 April. Notwithstanding the timelines contained in this regulation, but subject to the provisions in this code, the period of lockdown imposed by the CG in the COVID-19 outbreak shall not be counted for the purpose of timeline for any activity that could not be completed due to such lockdown in relation to the CIRP. Regulation 48 provides the model timeline for CIRP process. Done. Chapter 2. All the best.